All right. I will call this meeting of the Senate Judiciary Committee to order. Will the secretary please take the roll?
Senator Harris, Senator Orenshaw, Senator Dondero Loop, Senator Wynn, Senator Hansen, Senator Krasner, Senator Stone, Chair Scheibel.
Here. Thank you very much. We have everybody present. So we will start with the first item on our agenda, which is our work session. Thank you all also for making noon work this week. We're going to be a little bit flexible with the schedule as we reach our deadline. And I just want to say one more time for anybody who doesn't already know this, that all of these hardworking senators sit on other committees. They have to present bills. They have to go to work sessions. And so you may see them come and go throughout the committee, and they have permission to do that. And I hope you don't take it as a sign of disrespect. But we want to make sure that every bill in this building gets a proper hearing, including those that you're here for today, as well as the other ones that are being presented in work session in other committees today. So with that being said, we will open up the work session, starting with SB 171. And I will turn it over to our policy analyst, Patrick Guinan, to walk us through the work session document.
Thanks, Chair. Patrick Guinan for the record. As the Chair mentioned, first bill in the work session today is SB 171. This is Senator Harris's bill, and we heard it here on April 6th. Senate Bill 171 prohibits a person from purchasing, owning, or having possession, control, or custody of a firearm who has been convicted in the immediately preceding 10 years of committing or attempting to commit an offense that is a gross misdemeanor constituting a hate crime under Nevada law or federal, other state, territory, or district law that prohibits the same or similar conduct. The same prohibitions on firearms apply if the person has been convicted of committing or attempting to commit certain violent offenses that constitute a hate crime. The provisions of the bill do not apply to a person who was convicted of any of these offenses prior to July 1 of 2023. That's all I have, Chair.
All right. Are there any questions about SB 171? Not seeing any questions, I would accept a motion to do pass. There is a motion from Senator Orenshaw and a second from Senator Wynn. Any discussion on the motion? Senator Hansen.
Thanks, Madam Chair. I'm voting no on this. I think a gross misdemeanor is way too low a standard to take away somebody's constitutional right. Right now, if the same act was a felony, it would automatically be a suspension. Secondly, I'm very concerned about the 10-year window for a gross misdemeanor and also the lack of uniform applications when it comes to hate crimes. There is a vagueness to it, and it's not applied uniformly to different bodies of people, and therefore I think this is a mistake and it's wrong. As you know, I've been against the whole hate crime concept for a long time because of those very reasons. And to now lower the bar to gross misdemeanor statutes, I am aware that in domestic violence situations that is the case. I'm honestly concerned about that, and that's not a 10-year window that I know of either. So I will be voting no on this because I simply think that when you lower the bar that far on a constitutional right, you're crossing a line. If we are that concerned about these types of things, we should be making this a felony, not just a gross misdemeanor. Thank you, Madam Chair.
All right. Thank you for your comments. Anybody else? All right. Not seeing any, we will move to a vote on the do pass motion for SB 171. All in favor say aye. Aye. Any opposed, nay. All right. It appears that Stone, Krasner, and Hansen are the nays. The rest are yeas, so the motion does pass, and I will assign the floor statement to Senator Harris. That takes us to SB 174.
Thanks, Chair. Senate Bill 174 is sponsored by Senator Hammond. We heard it here on March 7th. This is a bill that relates to common interest communities. It removes from statute an exemption that allows a community manager in a common interest community to collect debts or contract with a collection agency to collect debts included in an association's lien without being licensed as a collection agency. There is a, There's an amendment proposed to the bill by the sponsor, which is attached to this work session document. It would allow an association manager to process all pre-collection notices, courtesy notices, intent to liens, and other mailings prior to a notice of delinquent assessment being processed. That's all I have, Chair.
All right. Are there any questions on the bill or the amendment? Good thing, because I don't see the sponsor here to answer them. I would accept a motion to amend and do pass. We have a motion from Senator Wynn, a second from Senator Harris. Any discussion on the motion? Sorry, we were discussing whether we had discussion. Looks like we don't. So we will go to a vote on the amend and do pass for SB 174. All in favor say aye. Aye. Any opposed, nay. All right, we have one nay from Senator Don Darrow Loop. The motion still passes, and I will assign the floor statement to Senator Hammond. That takes us to SB 362.
Thanks, Chair. Senate Bill 362 is a public safety bill sponsored by Senator Neal and others. We just heard it here on April 7th. Senate Bill 362 requires that if a person who is in the custody of a peace officer indicates that he or she cannot breathe, the peace officer must ensure that medical aid is rendered to the person by an appropriate medical practitioner as soon as practicable. The bill also provides that the Department of Motor Vehicles may adopt regulations governing the use of a single symbol on a driver's license to indicate that a person may have a certain medical condition or conditions and to maintain a record of such that will be accessible to law enforcement agencies. The department is also to make information available on its website regarding how a person may obtain a license with such a symbol imprinted on it. And the bill prohibits a peace officer from performing or causing to be performed while on duty any copyrighted work. There is an amendment to the bill relating to the copyright issue. It revises provisions regarding the prohibition on an officer using copyrighted work to require law enforcement agencies to adopt policies preventing peace officers from weaponizing copyrighted work to interfere with the sharing of recordings made of peace officers while on duty. And that's all I have, Chair.
All right, any questions on the bill or the amendment? I don't see any, so I'll accept a motion to amend and do pass. We have a motion from Senator Wynn and a second from Senator Orenshaw. Any discussion on the motion? Not seeing any, we'll move to a vote. All in favor say aye. Aye. Any opposed, nay. All right, the vote is unanimous to amend and do pass Senate Bill 362, and I will assign the floor statement to Senator Neal. That takes us to SB 378.
Thanks, Chair. Senate Bill 378 is sponsored by Majority Leader Canizaro. We heard it here on the 3rd of April. It revises provisions concerning which documents a common interest community association with 150 or more units must make available on its website, and removes the requirement that such an association must make it possible for a unit owner to pay assessments electronically. It provides instead that an association may allow payments to be made electronically if certain conditions are met. It eliminates provisions requiring that certain notices be delivered by mail, providing instead that these be sent by email in most circumstances, and providing the manner by which notices must be delivered when email is not used. And finally, it authorizes an association to purchase a unit at a foreclosure sale by a credit bid up to the amount of any unpaid assessments and any permitted costs, fees, and expenses incident to the enforcement of the association's lien. There are no amendments.
All right, are there any questions about this bill? Not seeing any, I would accept a motion to do pass. All right, there's a motion from Senator Orenshaw and a second from Senator Wynn. Any discussion on the motion? Not seeing any, we will move to a vote on the motion to do pass Senate Bill 378. All in favor say aye. Aye. Any opposed, nay. The vote is unanimous. Do pass on Senate Bill 378, and I will assign the floor statement to Majority Leader Canizaro. And that brings us to the last bill on our work session for today, SB 395.
Thanks, Chair. Senate Bill 395 is sponsored by Senator Neal. It relates to real property, and we heard it here on April 7th. The bill provides that the Securities Division of the Office of the Secretary of State will create and maintain a registry of corporations and limited liability companies that purchase or own residential property in this state, and to make the registry available online. These business entities are required to register with the division before purchasing any residential real property in Nevada, and the division may charge a fee for such. A county clerk is not to record a deed concerning the purchase of such property unless the deed contains information about the ownership of the entity, and the deed must make clear that the property is not the owner's primary residence. Senator Neal offered an amendment at the initial hearing. It's attached on the following page for your review. It excludes family trusts and Nevada Housing Authority transactions from the bill. It adds language to protect against aggregate purchases, limits investor purchases to $1,000 per year, and excludes transactions where the sell date and construction date are the same. It replaces clerk with recorder where appropriate, and requires a recorder to make sure that the filing name matches the name registered with the Secretary of State, and to mandate that the form filed with the Secretary of State accompany the deed recording regardless of whether the transaction is in cash. And I would just note, this bill is in skeleton form, Chair. That's all I have.
All right, any questions about SB 395 or the amendment? I don't see any, so I would accept a motion to amend and do pass. All right, we have a motion from Senator Wynn. We have a second from Senator Orenshaw and Senator Hansen. But we'll go to a vote on the motion to amend and do, sorry, any discussion
Yes,
on the
ma'am.
motion?
Madam Chair.
Senator Stone.
I'm going to be voting no today, but I don't reserve the right to switch my vote on the floor. Thank you.
All right. Seeing no further discussion, all in favor say aye. Aye. Any opposed, nay. All right, we have Senator Stone in opposition. The rest vote to pass. And with that, I will assign the floor statement to Senator Neal. That takes us to the conclusion of our work session. It is my intent to hear the bills in the order that they're listed on the agenda this afternoon. So that would mean we would start with SB 284, then 322, and then 417. So I see that we have our presenters all here for SB 284. Please go ahead whenever you're ready.
Thank you, Mayor. Chair Scheibel, I very much appreciate the honor of being here in front of you today in front of the Senate Committee on Judiciary. I am Senator Dr. Robin Titus. I represent Senate District 17, which includes all of Douglas, Lyon, Churchill, Esmeralda, Mineral counties, and part of Nye, specifically Tonopah. And this is actually the first time in my 5th session that I've had the privilege of being in front of Judiciary. I wonder what I've been doing all my 5 sessions. So I am here to present Senate Bill 284. Joining me as my co-presenters are Paula Montanucci and Mark Jackson. Mark is a Douglas County District Attorney, and Paula is the reason that I'm sitting here. Also in the audience, I have Kirk Widmar. He's the Chief Offender Management Division for the state prison systems, and if there's any questions on process, he's here as a neutral person for that information. SB 284 is an act relating to offenders, reviving provisions relating to the assignment of certain offenders to an institution or facility of minimum security, and providing other matters properly relating thereof. This bill addresses a section of NRS which relates to the sentencing of persons imprisoned for driving under the influence of controlled substance or under the influence of intoxicating liquor. Current law states that a person so imprisoned must, insofar as practical, be segregated from offenders whose crimes are violent, and insofar as practical, be assigned to an institution or facility of minimum security. This is for driving while impaired, regardless of whether it's a third DUI or not. I might point out that if a person is driving recklessly and they kill someone, they can be charged with manslaughter and go directly to prison. However, the laws for a third DUI involving manslaughter or death are not the same. This last fall, Paula Montanucci reached out to me regarding these laws. Paula's life, as has happened to way too many folks, was drastically changed due to a drunk driver. I'm going to ask Paula to tell her story, and then I'm going to have Mr. Jackson go through the bill text itself and the changes that we are suggesting. Paula?
Yes. Thank you so much for your time and the opportunity to be here today, to be heard. I have a letter that I would like to read, if I just may have your attention for just a few moments, and then just a few comments. Thank you. Hello, my name is Paula Montanucci, and I am the mother of Fallon Taylor Montanucci and Avalon Marie Montanucci, who were the victims of a drunk driver last April in their hometown of Minden, Nevada. In the collision, myself and so many others lost a treasured individual, Airman First Class, my oldest daughter, Fallon. As I'm sure many of you can imagine, losing my 22-year-old daughter in the most unbelievable, violent, and heinous way is too much for me to bear. Not to mention now still dealing with the emotional loss of my youngest daughter due to irreversible physical and mental damage. From day one, my girls were always taught to love and cherish each other above all. Of course, this came naturally to Avalon, as she was always the softer of the two, and Fallon being her perfect match with her strong energy and protective nature, which came tragically into play in her final moments, turning the wheel, taking the full force of the truck that came at them at over 100 miles an hour on the wrong side of the road. These girls were so much more than this moment. As I write this, I recall all the memories they made. If one of them was sick, and the other would calmly take the position as a mother. When it came to signing permission slips or learning how to drive, they were always there for one another. I remember all the plans they had made together, and often I would hear over the dinner conversations they'd have about growing up together and having families of their own. Both of my daughters were always beloved by their teacher. They always made it a point to excel in everything that they did, especially school, always bringing home the best of grades. They even went so far as to get involved in the community from a young age, being involved in the STOP programs and the GREAT programs, which aim to educate the youth of Douglas County in the fight against drugs and violent crimes. Avalon even successfully started an anti-bullying campaign in 6th grade, and Fallon, being the shy girl that she was often more interested in sports. In elementary school, she was discovered and put on the elite jump roping team, Jump Rope for Heart, which aimed to raise funds for the effort to fight heart disease. My little girls were involved in the community at such a young age, making a difference to their peers and trying to make that difference because of the foundation that we gave to them and the community that they grew up in. They loved it. Fallon began to find her confidence, as she was very shy. She always kept busy training and running on her own. And in the following years, she participated in volleyball and in track, and we can go on and on and on. I don't want to take too much of your time, but I do want to say that after high school, Fallon continued to work hard. She worked hard at a daycare center full-time, and she went to college full-time. After graduating with her associate, she made the honorable decision to join the United States Air Force. She was perfect for that life of service. She was always regimented and had that Nevada girl grit. That's how I raised both of my girls. She was stationed at Malmstrom Air Force Base in Great Falls, Montana. She continued her education while in service, majoring in psychology. She was only 2 weeks away from finishing her bachelor's degree before the collision, and Avalon was only 2 weeks away from finishing her associate's degree. Fallon proudly planned on continuing with her master's. She practiced her passion for helping others as she participated in helping children at the local middle school up in Montana, where she prepared the students, the 7th and 8th graders, for a statewide science competition. And Fallon, unfortunately, didn't have the opportunity to see that her kids actually won first in the state, and she worked months and months to help these kids. The point I'm making is that my girls give back to the community, and that's how they were. Fallon, when I saw her, we tried to get her home for, God, it must have been 4 months, and it was one thing or another. The flights were delayed. It was the weather. It was this or it was that. And finally, right before Easter, we were able to get her home last year. And it was so nice to see her come home. If you guys have children or grandchildren, when your kids get right to that point where they're ready to launch, you know, it's like everything that we've done, everything that they've gathered from the point that they were born to the point that they're at now, it's like, I want to be just like you. And I had the opportunity to tell her that because she was amazing, and she was ready to just take that next step, and we were all excited to see what that was. Unfortunately, the night of Saturday, April 23rd, the girls were driving home from a friend's house, and they were 7 minutes away from home, just 7 minutes away from home. And, you know, you see in the movies those officers that pull up to your house. Well, 6 officers pulled up to my house that morning, and, you know, my daughters are out, and I just want to tell myself, God, please just let them be in trouble. But I knew that they couldn't be in trouble because I know the kind of girls that I raised, and I knew it was something more, and I knew the man that came to my door. I grew up with him. He's one of the sergeants, and I knew that look on his face. And I don't see my girls anywhere. And I had to ask, where's my daughters? Which one? It was Fallon. How do I get to Avalon? Well, sorry, ma'am, you can't take Minden, Nevada. You can't take Highway 395 because they're still cleaning up your other daughter off the highway. So you'll have to take the long way through Genoa to go get your other daughter who's been care flighted to Renowned. You take your sick husband with you who just had a 5-artery heart bypass and has metastasized prostate cancer, and get yourself there, ma'am. The only thing that we can tell you is that she knows her birth date and she knows how old she is. And I get myself to Reno, and I see my little girl there, and she doesn't even look like her. The injuries are multiple. In fact, at the accident site, they didn't even know she was in the car because my daughters were hit head-on by a Ford F-150 that was full of concrete material by a man that didn't even know which way was up. My little girls, he was going over 102. He hit my little girls head-on in a Hyundai Accent going 52 miles an hour, not an ounce of alcohol in my driver, Fallon. She did everything right. And there wasn't anything left of that car. They didn't even know Avalon was in there until they heard her and had to extract her out of there and care flight her to Reno. I got to Reno in the ICU unit just in enough time to see the surgeon in there to see what condition my daughter was in. And thankfully, she's sitting here with me today. It's been a journey. It just doesn't move on. I know my daughter isn't going to come back. I'm sitting in front of you here today because when that sentencing happened, I don't feel like justice had been done for my daughter. I feel like justice was done for her in Douglas County. As soon as she hit some sort of system here, it went wrong. This man who hit my daughters went to an honor camp. I was under the impression that he was going to go into Carson City and be evaluated to find out which prison he was going to. It turns out that he went to another honor camp up in Carlin, Elko, Nevada, God's country, where he's at right now, probably cleaning up sagebrush, getting ready to burn it for the fire season. He's out there enjoying himself, where my other daughters, who loved life, who didn't find it too hard to live every day, and didn't have to drink her problems away and knew how to get help if she needed it. She's sitting 6 feet under. Now, my daughter won't have a sister that she gets to grow up with and have babies with and everything that they had planned. It's gone. Our lives have changed. And I'm asking myself, what laws are diminishing here these last 5-7 years? What's happening? Is it's not happening enough? Are we not talking about it enough? Well, it happened to me. It happened to the wrong person. And this will not be the last time that you see me. I will see that these DUI laws strengthen. I want people, when they drive through Nevada, to be scared if the police officer rolls up behind them and they're doing something wrong. These are our children that are getting killed. These are our parents that are getting killed. These are innocent people that are doing everything right. Let's see a little justice. I need a little justice from this system today. I'm going to need to see a little justice for these families that don't see it and don't have a voice like I do, and the support that I have beside me and through entire communities. I will fight for my daughter because she deserves it, both of my daughters. So I think that we'd be a shame here today that if we didn't see justice for her. Thank you very much for your time.
Thank you, Madam Chair, for that, and Paula, for your testimony, heartfelt. Just a clarification, again, as she pointed out, one of the things, the issue here is this gentleman was sentenced and he went immediately to a work camp. He never saw a day in prison. And so that is what we're hoping to fix here. And so with that, we have reached out to the Douglas County District Attorney, Mark Jackson, to kind of give us an understanding of how we can fix some of these laws. And so it was through his suggestion, and that's why he is here at the table today, to go through the bill itself on what we're asking for you to support. So I'm going to turn that over to DA Jackson.
Thank you, Chair Scheibel, Senators. For the record, Mark Jackson, Douglas County District Attorney. I would like to add very briefly to the record some additional context regarding this case. The driver of the vehicle that caused the collision that killed Fallon and seriously injured her sister, Avalon, he went through a series of 3 blood draws in accordance with the law. His blood alcohol levels were a .217, a .206, and a .197. This wasn't his first offense. The sentencing judge was aware that he had his first DUI conviction in Douglas County in 2013, and that arrest stemmed from him drinking and driving and crashing his vehicle into a fence along a roadway, so there was some property damage. His second DUI arrest occurred 2.5 years later in Carson City. He was convicted in 2016. That offense also involved him driving a vehicle. He crashed it into a power box and stop sign, which resulted in a loss of power to residents in the area. He was also arrested in 2016 for being intoxicated and discharging a firearm within the city limits in Carson City. At the time of this offense, he was also had a pending criminal citation for driving in a dangerous manner. He was also a suspect in a battery case, and his blood alcohol level at that time was a .251, but the victims in the case did not want to cooperate and with the prosecution of that matter. He was sentenced on October 17th of 2022. He was charged with violations of NRS 484C.430. Count 1 was DUI causing the death of Fallon Montanucci. Count 2 was a DUI causing substantial bodily harm to Avalon Montanucci. The maximum punishment for each of those offenses was 20 years in prison. Under our current laws, that means that the maximum minimum parole eligibility would be 8 years. The sentencing judge did sentence the offender to 8 to 20 years on count 1 and 8 to 20 years on count 2. The aggregate sentence was 16 to 40 years. He was transported and received by Northern Nevada Correctional Center on October 19th of 2020. Less than 30 days later, on November 17th of 2022, October 19th, 2022. Less than 30 days later, on November 17th, he was then assigned to the work crew within communities outside of the prison, and that's the Stewart Conservation Camp, initially here in Carson City. It's the position of the Montanucci's, the Douglas County DA's office, that occurred without any punitive or rehabilitative justice being served in the case. To go through the bill, if you look at Section 1 of the bill, NRS 209.481, Chapter 209 is the Nevada Revised Statutes that governs the Nevada Department of Corrections. And within Chapter 209, it sets forth the powers and duties of the Board of the State Prison Commissioners, including the duty to prescribe regulations for carrying on the business of the board and the department. Also within Chapter 209 are the duties of the Director of the Department of Corrections. And that includes establishing regulations with the approval of the board, enforcing all of the laws governing the administration of the department, and the custody, care, and training of offenders. One of the approved regulations specifies the custody categories and the criteria within the department's institutions and facilities. Nevada Department of Correction Administrative Regulation 521 sets forth those classifications. And the classifications include maximum custody, closed custody, medium custody, high minimum custody, and then finally community trustee, which is through transitional housing. The minimum custody institutions in Nevada are facilities without secure perimeters. That's their definition. It includes the camps and the transition centers, and that's it. Under the current Nevada Department of Corrections regulations, one of the criteria that must be met for any other offender going to prison to be assigned to a minimum custody facility is that that offender has to be within 48 months of possible release from prison custody. That's Nevada Department of Correction Administrative Regulation 521.05. The department's administrative regulations on the assignment to minimum security facilities does conflict with the exceptions that are set forth in Section 1, those 7 specific delineated statutes under subsection 1A. These 7 exceptions, all 7 of them, are for felony driving under the influence or operating a vessel under the influence of alcohol or controlled substances. If you look at Section 1, subsection 1A of 209-481, the interlineation, NRS 484C 400 sets forth the penalty for driving under the influence of intoxicating liquor or controlled substances, a third offense. And the penalty for that statute is addressed in Section 2 of this bill. NRS 484C 410 sets the penalty for driving under the influence after having previously been convicted of felonious conduct or homicide. And the penalty statute is addressed in Section 3 of this bill. NRS 484C.430 sets the penalty for driving under the influence causing death or substantial bodily harm. And this penalty statute is addressed in Section 4 of the bill. NRS 484C.440 sets the penalty for vehicular homicide, and that penalty statute is addressed in Section 5 of this bill. I will note that of these 7 felonies that are listed here, 6 of them are Category B felonies. This 484C.440 vehicular homicide, that is a Category A felony. The next 3 statutes under NRS Chapter 488 deal with operating a vessel under the influence of intoxicating liquor or controlled substances. So NRS 484.420 is the penalty for operating the vessel causing death or substantial bodily harm, and that penalty statute is addressed in Section 6 of the bill. NRS 488.425 sets the penalty for homicide by vessel, and the penalty statute is addressed in Section 7 of this bill. And finally, as you'll see under Section 1, 209.41, subsection 1A, which is stricken by interlineation through this bill language, NRS 488.427, which is the penalty for second or subsequent felony operation of a vessel under the influence of intoxicating liquor or a controlled substance, and that is addressed in Section 8 of this bill. The language in Sections 2 through 8 of this bill are identical, and what this bill does in Sections 2 through 8 is remove the mandate that a prisoner be immediately assigned to a minimum custody facility if that person is convicted of one or more of the 7 enumerated sections 2 through 8. The result of this bill is that it would revise the penalties for those 7 enumerated felonies by treating the classification and custody category for those offenders the same as other offenders with respect to eligibility for assignment to an institution or facility of minimum security until that person meets all of the criteria set forth in the Department of Corrections administrative regulations. How this would work, a person that was convicted of a DUI third offense, it's a Category B felony, and they're going to be sentenced up to 6 years in prison. Well, from day one, that person's going to be within 4 years of release from the prison. So that type of offender with these changes would still be eligible, if determined by the Department of Corrections, to be put into a minimum custody facility. But it's the other 6 that dealing with causing death, substantial bodily harm, vehicular homicide, previous felony, those types of offenses where the person could be punished up to 20 years. Senator Titus gave one example about reckless driving, but another example is that if a person was involved in a collision and they left the scene, that person is subject to the same penalties as a DUI causing, and it results in a death or substantial bodily harm, would be subject to the same exact penalties as a DUI causing a death or substantial bodily harm. And I think that most people would agree that that situation is much more egregious and much more offensive than just leaving the scene, as offensive as that is. But that offender, for being involved in a collision and leaving the scene, would not be able to be put into a minimum custody facility until they're within 48 months of release. But we're allowing these exceptions that are carved in just for these DUI laws. And with that, I have no other comments on the language of the bill. Thank you, Senator.
Thank you, sir, and thank you, Chair, and the committee for hearing this bill. I just want to do a little follow-up in case there might be questions, and then we'll certainly take more questions. Currently, from information I received today, there are currently about 200 DUIs a year that are sentenced. Right now, we have 280 folks from DUIs in custody. Of those, 22 would no longer be allowed to be in minimal custody. So this would affect approximately 22 folks currently in custody. And with that, Madam Chair and members of this committee, I appreciate you hearing this bill for us. Hopefully we'll get your support on this, and we are happy to take questions.
All right, thank you. Any questions from members of the committee? Senator Wynn?
Thank you. I have a question, and I don't know if this might be better directed towards NDOC or Mr. Jackson might have the answers to it. Is I know that these some of these laws they didn't start like in the last 5 years. They've been in effect. I think some of the original like minimum security or maximum security distinctions were in the 1977 session, and then these DUI provisions were entered in 1983. So I'm wondering if we've seen a progression of this. How many people are put into honor camps as opposed to, I know that there's varying levels. And then my second question is I know that the NDOC, as a process of their, classification system, I guess, and when people are entering into the system, they have like regulations that they promulgated to put their officers in the best situation where they're going to be safe, put the inmates that are also incarcerated in areas that they are. So would this take away any of that? I'm assuming because they came up with these regulations, they thought that safety and rehabilitation and all of those things were taken into consideration. So I'm wondering what kind of conversations you've had with them about what their current processes are for classifying people. I know that was a very long-winded, like rambling question statement, so I guess any response would be appreciated.
For the record, Mark Jackson, Douglas County District Attorney. Chair Scheibel, do I go through you too?
Please go direct.
Okay. Thank you, Senator Wynn. As to both of those, Kirk Widmer is here. I think he's best situated to answer both of those questions. I will tell you that we had invited Kirk Widmer and other individuals from the Department of Corrections. They came to Douglas County. They presented to the prosecutors, to our judges, to the defense bar about not only the prison math, but specific to these particular issues. So I don't want to repeat some of the things that he said because I may get something wrong.
And then my follow-up question that he might be able to answer too is sometimes I've seen reading in the paper, and I don't know if that was the circumstance in this particular situation, is that sometimes people will be charged with the DUI resulting in death or substantial bodily harm, but other felony charges that they might be convicted of. If that's the case, does the person go to are they eligible for that diversion into like a camp, or are they placed in general population? Does that make sense? So if you have a stop required on signal of an officer, which is a felony, but you also have a DUI resulting in death or substantial bodily harm, where is the placement then in those circumstances?
Thank you for the question. Kirk Widmar, WIDMAR for the Department of Corrections, Chief of the Offender Management Division. Let me see if I can get all three of those questions right. To the first point, like Senator Titus, we average about 200 new admits a year that our DUI is the most serious offense in the category of their JOCs. Kind of answers your second part. Yes, they could have multiple other charges associated with just that DUI. The current DUI statute, when we are just dealing with a DUI conviction, that's that exception that's currently carved out specific to those charges. And that's where we see where offenders with traditionally longer minimums and maximums are able to go to camp under just the DUI statutes. Where an offender committing a different crime with a min and max outside of the scope of the 48 months, and by the way, D.A. Jackson did an excellent synopsis of our policy. I believe he was very accurate, and so thank you for that. When we review these offenders upon intake, first and foremost, that's what we're looking at. We're looking at all the criminal history. We're looking at prior incarcerations. We're looking at all those, and then ultimately the JOC, which drives the whole ship. What did the judge sentence to? What type of felony charge did the sentence to? And what other mitigating or aggravating factors are involved with not only the JOC, but also the pre-sentence investigation that's provided to us that was used through the hearing process. When we are dealing with just a DUI case, we are obviously held to the standard of law dealing with those cases. Currently under statute, those offenders are allowed to go to minimum custody in any one of those categories. The only exception to that will be is if there is another charge involved, whether it run concurrent or consecutive, that requires us to consider the felony, and then with that 48 months to possible release comes into play related to minimum custody. Just to help clarify just a few, currently we have 280 offenders at minimum custody that are sentenced under DUI. Like Senator Titus indicated, based on the language in this law, 22 of those offenders would fall outside of now minimum eligibility if the law is passed as written. They would have to wait to that 48-month window to become eligible to be considered to go to minimum custody. Did I get all the points, I think?
I guess to follow up, I'm not as familiar with this, but it's my understanding that reckless driving, so if you have a reckless driving with death, you will be populated in a typical prison setting. And if you have a DUI with death, then you're eligible for this, or you're diverted into this camp situation. Is that right?
That is accurate, Senator.
Okay. And then I have a question. With the DUI third, so just like the B felony 1 to 6, are they diverted into a camp, or do they serve their time in the prison?
So,
It kind of seems like they're not included in that either. So it's only limited to DUI death or substantial bodily harm?
Kirk Whitmore, for the record, no. A third DUI 1 to 6 would be immediately minimum eligible to go. Currently, under current statute, and quite honestly with the provision, because they're within that 48 months.
Okay. So maybe I can clarify with legal. So they can go to camp if it's a DUI third, but they are not automatically diverted if it's like a DUI death. Is that, or maybe our policy analyst might.
Carly O'Crenton for the record. I'm not sure that I'm quite clear on what question you're asking. Would you mind repeating it?
So if you have a DUI third offense, and let's say you're sentenced to 28 to 72 months, which is the maximum penalty for that particular offense, are you automatically eligible for an honor camp, or is it not within that 4 years, and so you're not?
If they are convicted of any one of the DUI laws and
Okay.
just the DUI itself, the outcome is the same.
Okay.
They go to minimum custody.
Okay, that's what I wanted to make sure. I was a little confused there. That's what I thought it was. Thank you.
Other questions from members of the committee? I don't see any other questions. All right, thank you. We will move into testimony in support of SB 284. Anybody wishing to testify is invited up to these chairs in the front of the room in Carson City or Las Vegas. And you can begin whenever you're ready.
Good afternoon, Chair Scheibel and members of the committee. Jennifer Noble on behalf of the Nevada District Attorneys Association. We are in support of this legislation, and we thank Senator Titus.
Good afternoon, Chair Scheibel and Senate Committee on Judiciary. Chris Reese, RIES, representing the Las Vegas Metropolitan Police Department. We also support SB 284. Thank you, Senator Titus.
Good afternoon, Chair, members of the committee. Jason Walker, Washington County Sheriff's Office, also testifying in support.
All right, I don't see anybody else coming to the table in Carson City, and I don't see anybody in Las Vegas, so we will go at the table, that is. There are people in Las Vegas. So we will go to the phones for testimony in support of SB 284.
If you would like to offer testimony in support of SB 284, please press star 9 now to take your place in the queue.
Good afternoon. I'm sorry, are you able to hear me?
Yes, go ahead.
Okay, hi. My name is Brennan White, and I work for Mothers Against Drunk Driving. I would just like to read a short support letter that we have through National and for Mad Nevada. So Senate Judiciary Committee members, Mothers Against Drunk Driving, or MAD, supports Senate Bill 284. This legislation will help to ensure that impaired drivers serve their time in a state prison as opposed to a low security facility such as an honor camp or work camp. Sending convicted impaired drivers to a low security facility or work camp sends a dangerous message to the community that choosing to drive impaired and killing someone isn't a violent crime, and also robs families of the sense of justice that can come with knowing offenders are serving their sentences in prison. The fact remains that every time someone makes the choice to get behind the wheel of a vehicle impaired, the danger and potential result is the same, loss of life. The problem of drunk driving is not going away in Nevada. According to the National Highway Traffic Safety Administration, 83 people were killed in drunk driving crashes in Nevada in 2020, representing 26% of all traffic crashes. Drunk and drug-impaired driving is a 100% preventable violent crime that requires consequences to ensure that the impaired driving law has teeth, but also justice for victims. Senate Bill 284 will ensure that impaired drivers who kill a victim will serve their time behind bars. For many victims that MAD serves, this requirement is imperative to help ensure justice. Senate Bill 284 still retains discretion to allow the state correctional facility director to place an offender in a low-level facility depending on certain criteria and circumstances. MAD urges you to support Senate Bill 284. Thank you for your time.
If you have just joined us and would like to offer testimony in support of SB 284, please press star 9 now to take your place in the queue.
Good afternoon, Chair Scheibel, members of the committee. Greg Herrera for the record, Herrera, representing Nevada Sheriffs and Chiefs Association. We are in support of Senate Bill 284 and would like to thank Senator Titus and District Attorney Jackson for bringing this bill forward, and also to Ms. Montanucci for having the courage to share your story. Our hearts are with you. We strongly urge you to join us in supporting SB 284. Thank you.
There are no other callers to offer testimony in support at this time.
All right, then we'll move to opposition testimony on SB 284. I don't see anybody coming to the table in Carson City or Las Vegas, so we will go to the phones for testimony in opposition to SB 284.
Thank you, Chair. The public lines are open and working. However, there are no callers to offer opposition testimony at this time.
All right, then we'll move to testimony in the neutral position on SB 284. Anybody wishing to give neutral testimony is invited to the front, and I don't see anybody in Carson City or Las Vegas, so we'll go to the phones, please.
Thank you, Chair. There are still no callers to offer neutral testimony at this time.
All right, I'll invite the sponsors back up to make any closing remarks.
I just want to thank the chair of the committee and the members of this committee for hearing this bill and giving us a moment in time. Thank you.
Thank you so much for your presentation. Thank you, Ms. Montanucci, Avalon, and it looks like you have some other family here with you for taking the time to come down here and speak with us today. We certainly appreciate your investment in this process, and we're sorry for your loss. With that said, I will close the hearing on SB 284. I will open up the hearing on SB 322.
Good afternoon, Chair Scheibel, Vice Chair Harris, and members of the Judiciary Committee. Thank you for allowing me to present this important bill today. We've heard time to time that what we experience and witness in our present lives often drives our desires to author legislation. This is one such case. My first email as a newly elected senator for District 20 came to me one evening while I was watching television with my wife, Regina. It was an email from a Henderson resident named Jason Patchett. As I started reading it, I was extremely moved the content and the email. from a grieving father. I stopped what I was doing and immediately called Jason, and then heard the horrific details of this terrible incident that resulted in the loss of his beloved son, Rex. Jason then informed me the perpetrator was a 20-year-old that was going to be sentenced for this crime very soon. The range of punishment under existing law is 1 to 6 years in prison for the exhibition of speed and taking the life of another. Jason made the argument that the punishment did not match the crime and that the law needed to be changed. Assemblyman Toby Urick, who also shares my district, was also called by Jason, and we all reached the same conclusion. We needed to ensure that Rex's life would be remembered not only to his loving family, but to other kids that could find themselves killed under similar circumstances. Chair Scheibel and members of the Judiciary Committee, I would like to introduce Mr. Jason Padgett, who will be speaking on behalf of his family who are here today, and introduce his two presenters. Then I will go over the details of the bill, and Assemblyman Urick, if he's able to be here, will deliver some remarks as well. So I'd like to introduce Mr. Jason Padgett.
Thank you.
State your name for the record.
For the record, my name is Jason Patchett, Jason Patchett. Good afternoon, Madam Chair, committee members. Thank you so much for allowing me to be here today. Thank you, Senator Stone, Assemblyman Urick. Appreciate the championship that you guys put forward in regards to this bill. I'd like to recognize my wife and my two children here. One of my sons is in Arizona, wasn't able to make it. My two other children are here. So my wife Samantha and my son Luke and my daughter Bella are here with me. And I speak on their behalf as well. I sit before you this afternoon as a father of a child who was violently killed by a reckless driver 13 months ago. I speak to you today as a victim of reckless driving. Words cannot begin to adequately describe the horror that my family and I are plagued with day in and day out. We have forever been so deeply and painfully hurt by the senseless killing of our precious son and brother Rex. It has completely and utterly uprooted our lives in ways unimaginable. Our plea to you today is that you see it within your hearts to fully consider why SB 322 matters to your constituents and to all Nevadans, why it matters to the children of our great state. Justice requires holding those who commit heinous criminal acts within our community accountable for their atrocities, especially when the victims of these heinous crimes are our children. It's time to send a strong, effective message to those who decide to wreak mayhem on our roadways and drive criminally reckless. It seems each time you turn on the news, there is yet another report of an innocent pedestrian senselessly killed at the hands of someone behind the wheel of a vehicle. Vehicle violence in our community is sadly an epidemic, and it's frankly disgusting. This egregious and criminal behavior must not be tolerated. Handing down stronger sentences to criminals will first and foremost bring some sense of justice for the victims, their families, friends, and community members, and will also send a strong, clear message that the citizens of the state of Nevada have zero tolerance for the vehicle violence perpetrated on our roadways, especially within the roadways of our neighborhoods and near and around our children's schools. On March 7th, 2022, our 13-year-old son, Rex Patchett, while on a sidewalk in front of his middle school, was violently struck and killed by a reckless driver. In the days following the senseless killing of my son, we learned of the egregious facts and circumstances surrounding the events of March 7th. Facts and circumstances that have occupied our minds daily. Facts and circumstances that terrorize us each second of our lives. Facts and circumstances that have truly shaken us to the core. Around 5 p.m. on March 7th, a 21-year-old driver, who I'll refer to as the defendant, while driving his black 2006 Ford Mustang sports car with 3 other adult passengers, had been observed by bystanders driving recklessly along the roadway in front of Mannion Middle School in Henderson, Nevada for several minutes prior to the collision. One bystander stated that he witnessed the black Mustang enter the roundabout between the middle school and the elementary school at a high rate of speed, do a full 360 while fishtailing around the roundabout, almost strike the bystander and another car in the area, and then proceed west on Paradise Hills at a high rate of speed while continuing to swerve and fishtail up the road. Seconds before Rex was killed, the defendant began driving at an excessive speed east on Paradise Hills Road in the number 1 travel lane, directly towards a well-known and significant bump in the roadway, which for years has provided extremely reckless thrill seekers the opportunity to jump their vehicles into the air. Once the defendant's sports car struck the bump in the roadway, the defendant lost control of his vehicle, struck the curb, rotated approximately 90 degrees counterclockwise, slid along the curb and the sidewalk, violently struck Rex, who was on that sidewalk, causing him to become airborne and land in the landscaped area of the middle school, where he succumbed to his injuries. Police determined that upon losing control of his vehicle, the defendant was operating his vehicle at an approximate speed of 97.42 miles per hour. Yes, 97.42 miles per hour in front of a middle school, near an elementary school, at a time of day where the likelihood of children present along the sidewalk is almost an absolute, in an exclusively residential neighborhood, and in an area with a posted speed limit of 35 miles per hour, almost 3 times the speed limit. Our feelings and knowledge of these egregious facts and circumstances concerning that horrendous evening on March 7, 2022, haunt us each second of every day. They haunt me as I sit before you today. This is our painful reality, and one that we have been forced into with no way to escape. On March 7th, my family and I were sentenced to life in the prison of all prisons, the prison of lifelong pain, grief, fear, uncertainty, loss, anger, sorrow, heartache, despair, hopelessness, and complete sadness. We were given no leniency, plea deal, suspended sentence, or probation. No, we were given nothing to save or pardon us from the hellish consequences of the defendant's actions on March 7, 2022. We are forced, through someone else's selfish and criminal choices, to suffer our entire lives with the brutally painful reality that our beautiful, precious 13-year-old son and brother Rex is gone, dead, violently killed at the hands of a reckless driver. Currently, the sentence for a conviction of reckless driving resulting in death is a minimum of 1 year to a maximum of 6 years in prison. And the sentence can be suspended or probation may be granted. As a comparison, the sentence for a conviction of DUI resulting in death is a minimum of 2 years to a maximum of 20 years in prison, and the sentence cannot be suspended or probation cannot be granted. The only difference in most DUI cases that result in death and reckless driving cases that result in death is the element of impairment. If the person who killed my son had been under the influence, the penalty would have been substantially different. The choice to drive while impaired must be punished, and currently Nevada law allows for just that. The choice to drive 97 miles per hour in a 35-mile-an-hour zone in front of a school in a highly residential neighborhood at a time of day where children are present, all while 100% stone cold sober, in complete control of one's decision-making and physical abilities, must also be similarly, if not equally, punished. However, under Nevada law, it is not. The potential sentence of 1 to 6 years in prison does not provide adequate justice for such an egregious case of reckless driving. Simply put, the punishment does not match the crime. Madam Chair, members of the Judiciary Committee, if the facts of a reckless driving case are so egregious as the facts I just described to you, and those facts do not warrant a prison sentence of more than 6 years, then I cannot, for the life of me, even begin to imagine, nor would I even want to imagine, a set of facts more egregious or more extreme that would. We need to do better. We need to enable our judges with the legal means necessary to hand down appropriate sentences in cases of felony reckless driving that are so egregious and so reckless. Senate Bill 322 does just that. Now I know that Senate Bill 322 is not going to bring my son back. Nor will it increase the penalty for the reckless driver who killed my son. So why is my family and I here today? Why am I testifying before you this afternoon? The reason is simple. My family and I are here today because of the way our son and brother Rex Patchett chose to live his 13 years of life. I would like to share something with each of you that my wife and I have learned about our dear sweet boy over the past 13 months since his death. Shortly after his death, a friend of mine contacted me and shared something that his son had shared with him. In the words of my friend's son, he wrote, quote, "On Tuesday, the day after Rex's death, I was walking to PE at Mannion Middle School. I noticed that one of my friends, who has a disability, was crying. When I asked what was wrong, he said only 2 words to me, the crash. It immediately hit me. He was one of Rex's many good friends. As we continued to walk into the locker room, I told him how Rex was an amazing kid. He turned to me and said, he was my only friend when I came to this school. He then told me how Rex had become one of his best friends he had at the school and how bad he missed him. Anyways, the main idea I'm trying to get across is Rex is a great person and a friend who has impacted the lives of many, many people." Close quote. A couple weeks ago, I received a direct message on social media from someone I don't know personally, but whose daughter happened to know Rex. She shared with me the following, quote, "My oldest daughter was in the same grade as Rex, and she was going through some puberty-related awkwardness in the 8th grade. A ton of the other kids would call her names and make fun of her. Most of those kids were in Rex's circle of friends, but she would tell me how Rex would always jump on them and tell them to leave her alone and that stuff is not cool. That would always make me smile, knowing someone was helping her at school." Close quote. You see, Rex lived his life helping those around him, whether it was being a friend to those that needed one, or standing up and defending someone because it was the right thing to do. Rex was selfless and truly loved to help other people. Senate Bill 322 is our family's effort to continue Rex's legacy, to help other people. This bill is about mitigating an existential threat that plagues our communities by stiffening the penalties for reckless driving. This bill is about standing up for the countless victims of reckless driving and providing adequate justice for them. It is about helping the next family that will unfortunately find themselves in our shoes. This bill is about our family members, our friends, our neighbors, and all our fellow Nevadans. Let's continue Rex's legacy and pass Senate Bill 322. Let's do it for Rex. Thank you, Madam Chair. Thank you, members of the Judiciary Committee. And thank you, Senator Jeff Stone and Assemblyman Toby Urick. At this time, I would like to introduce Ms. Erin Brim. She will address the committee, and also following her, if she is available, she was going to tune in via Zoom, is Dr. Deborah Cools. And I don't know if she's been able to connect or not. And we'll go at that point. Thank you.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. For the record, my name is Erin Breen. It is E-R-I-N, B as in boy, R-E-E-N. I am the director of the Road Equity Alliance Program in the Transportation Research Center in the College of Engineering at UNLV. I'd like to thank Senator Stone for inviting me to provide you with some background information today for SB 322, Rex's Law. I'd also like to thank Jason and his family for their bravery sharing their story with you today. I wish I could tell you that Jason Patchett was the first parent that I've met whose child was killed by a reckless driver. But I can't. I wish I could tell you that Jason was the first parent of a young person that I've worked with whose child died on a sidewalk due to reckless driving. But sadly, that would not be true. Nor would he be the second or the third or the fourth. Speed, as I'm sure you know, is one of the top 2 causes of fatal crashes in Nevada. Impairment is the other. In fact, I was concerned that many would feel that reckless driving always went with impaired driving and think that this bill was unnecessary. So today I wanted to share with you what the facts in Nevada are. I'm sharing data for the past 5 years, 2018 through 2022, which may not be complete. 2022 numbers will continue to roll in for several months. This will be data that was cited as reckless driving as the primary cause and was either a fatal crash or a crash that resulted in life-altering injuries. In the field, we still use the CABCO scoring scale. K is fatal and A is incapacitating or life-changing. B is injured, C is injury claimed, and 0 is no injury. This is from the law enforcement and EMS people in the field. We have had 210 such crashes that reached the fatal or incapacitating level when reckless driving was the top contributing factor in our state. Even 210 is a large enough number that it's difficult to visualize, which makes it easier to dismiss. 210 represents a lot of pain and suffering, but by year, I'd like to break it down further. We had 31 such fatal or incapacitating crashes in 2018, 34 in 2019, 44 in 2020, 44 in 2021, and 51 in 2022, which again may not be complete. Broken down even further, 80% of the crashes were in Clark County, 11% were in Washoe County, and of course 9% in the rural areas of Nevada. Looking at the ages of the reckless drivers themselves, those between the ages of 21 and 34, far and away the largest group. In fact, all other ages combined don't add up to the numbers in that 21 to 34-year-old age group. Is it a factor of maturity? Should we and could we do a better job of warning young people of the dangers involved with bad decisions? Because after all, that's what reckless driving comes down to, bad choices. The answer is always yes, especially when we're talking about males under the age of 30, whose decision-making skills are really not complete until this age. Sticking with the young driver, as I put this together yesterday, I wanted to break it down a little further. And so I looked at this 21 to 34-year-old age group and pulled out the 21 to 29-year-olds and then the 30 to 34-year-olds. So there were 73 of those drivers that were 21 to 29 and 33 who were 30 to 34. That 30 to 34-year-old group is about the same as the 16 to 20-year-old group. And again, that's a 4-year increment versus our traditional in traffic safety 10-year block, which is why I wanted to break it out further for you. Involvement due to crashes because of bad decisions drops dramatically after that 34-year-old age group. Consequences for behaviors are a strong deterrent, and teaching early and often that bad decisions behind the wheel that result in substantial bodily harm or death will send you to jail for 10 years could literally stop the average driver from having this kind of behavior. I often say people drive like there are no consequences because there aren't. SB 322 could be the tool we're looking for in the toolbox of driver education. We live in a state where speed is discussed far too often. Even the legal speeds are too fast for those struck by a vehicle walking or riding a bike. Our pedestrian numbers are higher than they've ever been. Our bicycle fatalities last year were triple the worst year we've ever had. Drivers losing control, leaving the street network and coming onto a sidewalk, striking people walking or waiting at a bus stop is far too common. And it's become less of a high-profile news story over the last several years, which is just incredibly disturbing to me. In fact, just 10 days ago, a driver driving recklessly lost control and killed a man waiting for a bus stop. It barely made the news at all. And the news that covered it was reporting it only because it was also a hit-and-run crash, which is, again, far too common. So they were looking for this driver. The average number of pedestrians killed on the sidewalk in Clark County over the last 5 years has sadly risen to an average of 8. The Las Vegas Metropolitan Police Department has a team of 6 officers and a sergeant who are dedicated to stopping street racing, another form of reckless driving. In the first year of operation, they wrote 238 citations to those driving recklessly. Imagine needing a dedicated team of officers, but that's where we find ourselves. At a time when law enforcement is drastically understaffed, the number of citations written to people traveling over 100 miles an hour in Nevada has risen from a jaw-dropping 3,517 in 2019 to 4,415 in 2020 and 5,137 in 2021. This morning I received the 2022 numbers to date, which have actually dropped to 4,736, a decrease that I would attribute to the lack of officers on the street, because our crashes involving those who were critically injured or killed due to reckless driving have in fact increased. How many times have you been driving down the street and wondered about the people that are driving around you? Think about the drivers that you interact with every day and how many times they have put your life or the life of people that you love in danger, with zero regard for your safety or theirs. We need deterrence to this kind of behaviors, and SB 322 could help us a great deal in educating, especially young male drivers, about driving the roads in Nevada. I thank you for your time and attention today, and I'm happy to answer any questions that you might have.
I'd like to introduce Dr. Cools. She's streaming via Zoom. Dr. Cools.
Yes, good afternoon, and thank you, everyone, for the privilege of testifying. My name is Deborah Cools, and my last name is spelled Kuhls. I'm a trauma surgeon. I've been a trauma surgeon in Nevada for 23 years. I'm a professor of surgery at the new Kirk Kerkorian School of Medicine at UNLV, and I've worked at UMC my entire 23 years here. As many of you know, UMC is Nevada's only level 1 trauma center and Nevada's only pediatric trauma center. And I really thank all of you, members of the committee, Senator Stone, and I really commend Jason Patchett and his family for taking the initiative to redirect their grief to try to prevent other families from losing their loved ones. I'm going to speak to you today briefly based upon my experience as a trauma surgeon, and I also want to share insights from research that I and others have done to inform safety and policy initiatives. I wanted to disclose that I do receive funding from the Nevada Office of Traffic Safety for research. And I apologize, the lights in my office are motion detected and they go off and on. I would just say that as a trauma surgeon, I've literally treated thousands of patients who've been involved in auto versus pedestrian crashes. When I first moved here, I was just honestly horrified by the numbers of adults and children that I saw that are struck by vehicles. And I would just say that I have talked to the patients who can talk to me, most of which cannot. And I've talked with their parents, their families. And I want you all to realize that, you know, I think it's intuitively obvious that when a pedestrian is hit by a vehicle of any sort, it's a huge force in that pedestrians are at a tremendous risk. They're very vulnerable road users, as we call them. Even at low speeds, and I would say I finished a 4-day stint in our trauma ICU just yesterday, and I treated many patients who were hit by vehicles recently, and they have very, very serious injuries, many of whom those who survive, many will never return to a productive life. They will be dependent upon others to care for them. I have really witnessed the grief that I'm sure all of you felt during Mr. Patchett's testimony. I want you to also understand that those who survive and the surviving families, obviously they have grief for the rest of their lives. Those who survive have permanent physical and emotional injury. Many suffer depression and post-traumatic stress disorders as well. So just according to like physics, and you know, if a pedestrian could even survive being hit at nearly 100 miles an hour, the common graphs that are available to us, they really only go up to 90 miles an hour, and it's nearly 100% will die at that point. And so I just want you to understand the injuries that this child sustained. They're likely body-wide. There are certain injuries that can instantaneously kill someone, and they must have instantaneously killed Rex. I also want to just tell you that from my early days, in Nevada, I was so struck by all of the injured children. We get them at UMC, and that really motivated me to do research, to inform policy and to prevent injuries, to inform our injury prevention efforts. And I would say some of my very first patients were children whose parents thought they were safe, but they were anything but safe, and their lives were changed forever for those who survived. Our research also looks at behaviors of drivers, and I would just say, just a very few days ago, we published our quarterly newsletter, and it's called Trend, and it focused on reckless driving, which is very pertinent to today's testimony. And of those, 70% 30% of those citations resulted in a crash. And Aaron Breen did a great job of giving you some data. And I want to just share a little bit of additional data. So in the state of Nevada, our office has received information on citations for a 4-year period very recently. And these are non-adjudicated, so they haven't yet gone to trial and so forth. But in 4 years in Nevada, there were almost 40,000 citations for reckless driving, careless, reckless driving, aggressive driving, behaviors that impede traffic crashes. And as Aaron pointed out, the preponderance are younger and males in that regard. Speeding citations. I actually thought that our researchers who initially put these numbers together had made an error. And speeding citations in Nevada are just unbelievably high. And 30% of them involve speeding over 80 miles an hour, which is the maximum speed limit anywhere in Nevada. And, you know, these numbers all represent individual humans. And I think my experience in nearly 23 years here, I treat the individuals. I talk to their families. I talk to their families every day on rounds. And I see the death and destruction of human life that results from really irresponsible behavior of drivers. I really, again, commend all of you for hearing this bill and for the Patchett family and their bravery in coming forth, you know, a very short period of time from when they lost, you know, one of their family members. So I hope you will all take this information and this testimony and make the right decisions. There are a lot of bad things that happen in our world, and I see a lot of the consequences of those bad things in my work. But what motivates me is to help those that I can help and to help inform policy and other interventions that can somehow change this trend. So again, I thank you for your attention. I'm sorry I couldn't be there in person, but I hope my testimony is helpful to you, all of you, in making the right decision for the citizens of our state.
Thank you. Madam Chair, Senator Jeff Stone, for the record, again, I want to thank our two presenters for taking time out of their day to give us some very important testimony. Hopefully they'll be around in case there's any questions that might be directed towards them. I'd also like to introduce my fellow colleague, Assemblyman Toby Urick, who you may know is a former Henderson police officer that would like to give his perspective. We share our districts together, and I couldn't share it with a finer gentleman. Assemblyman.
Thank you, Senator. Thank you, Chair Scheibel, Vice Chair Harris, and the Senate Judiciary Committee. I have not had the chance to meet many of you yet, but for the record, I am Toby Urick, and I have the distinct pleasure of representing Nevada's Assembly District 19, which is the location of the tragic incident that brings us here today to hear SB 322. We're here to address a growing concern in our community, the rise of reckless driving and its heartbreaking consequences. And as Senator Stone indicated, I hope to offer a perspective that might be helpful. And that is because for 2 decades, I served as a police officer in the city of Henderson and had the unfortunate experience of responding to far too many traffic accidents where the thoughtless and negligent behavior of one individual led to the ultimate fate of another. Ingrained in my memory are countless images of dead, mutilated, and mangled bodies. I unfortunately saw how this heartbreak altered the lives of surviving family members who were forced to put the pieces of their lives back together long after the perpetrator who caused so much pain was set free to live their lives as normal. I want to begin and make sure that I acknowledge the distinction between the inherent risk of accidents that can occur in the normal course of driving and those that occur when an individual chooses to intentionally engage in extreme reckless conduct. It's already been suggested today that it's similar to when somebody chooses to drink and drive. There's an increased risk of substantial bodily harm and death because of that conscious choice to engage in destructive conduct which brings harm to another, and that is what we're hoping to address today. You've heard a lot of stats, and I won't go over a whole bunch, but in recent years we have seen an alarming increase in the number of deaths related to reckless driving, particularly in Las Vegas. The state data on traffic fatalities goes back only to 1991, and in 2022, we saw one of the highest traffic death counts in the past 32 years. The statistics are disturbing and speak of the urgency for a necessary response. Clark County saw an increase in deadly crashes last year with 246 fatalities, which is up 4% from 2021's 236 road deaths. Pedestrian deaths in the state rose 5% between 2021 and 2022, and cyclist deaths jumped 114%. Recent news reports suggest that between 2020 and 2022, tickets for Nevada drivers going over 100 miles per hour jumped 26%. And in 2020, more than 4,400 drivers were cited for driving at 100 miles per hour or more. Nearly 900 more than in 2019. Unfortunately, these aren't just numbers. They represent real people and their families and their loved ones who are left to grieve their devastating loss. One such tragedy is the story of 13-year-old Rex Patchett, who was struck and killed as he rode a scooter in front of his school by a reckless driver. The driver, who had been going more than 90 miles an hour, was recently sentenced to the maximum of 6 years in prison, but could serve as few as 2 years before being eligible for parole. This is unacceptable and painful to the victims' families who deserve equitable justice for their loss. We must take action to prevent such tragedies and to deter intentional, reckless driving by increasing the penalties for this irresponsible behavior. And that is the purpose of SB 322. And Chair, I believe with your permission, Senator Stone will walk us through the bill.
Thank you, Assemblyman Jeff Stone. And for the record, Madam Chair, I work closely with DAs and public defenders on this bill, and as a result, the amendment is before you. I want to thank Erica Roth, John Pirro, Jennifer Noble, and John Jones for their input and their time. Chief Deputy DA John Jones from Clark County will be here to help answer any questions as we get into the bill. So let me go into the bill. Each of you should have a copy of the amendment that I submitted, and I will be referring to it. The changes are, number one, we struck sections 1 and 2 completely from the bill. In section 3, subsection 9A, we retain the current 1 to 6 penalty for all cases except those covered by section 9B. In section 9B, we've added a new penalty of 1 to 10 for those offenses that involve a speed of 50 miles or more over the speed limit, or occur in a school or pedestrian safety zone. The remainder of the language in section 3 was struck. Also, in section 3.9B on page 7 of the amendment, lines 32 to 33, the modification allows for people convicted under this section to continue to be eligible for probation at the discretion of the judge. And lastly, I would respectfully request that this bill be indexed like other laws with namesakes to be referred to as Rex's Law. Madam Chair, we would be delighted to answer any questions that you or the committee have on this particular bill.
All right, thank you. And thank you, Mr. Patchett, for being here and for presenting to us today. And thank you to your family for taking the time to come all the way up to Carson City. We know it's not easy, and we appreciate your involvement in the process. Although, as I think I mentioned to you before, I wish we'd never met and that you had never come up here. So with that, I will open it up for questions. Senator Wynn.
Thank you. And I think we've talked about this enough. Obviously, I have been working with Senator Stone and Assemblyman Urick on trying to craft legislation. I know in talking with Senator Stone, and I appreciate him taking into consideration some of my concerns. When we look at our DUI laws, the penalties for DUI death or substantial bodily harm are actually some of the harshest in the country. And so when we put that in perspective, I always look at the parity of something like this, like a reckless driving, where there's arguably more intent that goes into the actions to drive at such a high speed in a school zone. So I appreciate some of these amendments that came in here to kind of narrowly tailor this. I know that we've had conversations about not wanting to get other people involved in this. You have young kids. I have younger kids, but they will be driving, I'm sure, soon enough. And so I know, and I appreciate you taking into consideration crafting some of the amendment language, because I think, like myself and other parents out there, sometimes there are tragic accidents that do happen. And I would hate for, unfortunately, if I had a child or we had a young person who was texting and driving and while that is horrible behavior that we should encourage people not to text and drive, I would hate for them to end up in this same penalty structure as the situation that unfortunately your family had to go through. So I do appreciate some of that language. And I also appreciate giving some of that discretion back to the judge with regarding the probation or non-probationable. I think that's appropriate as well. So I just wanted to kind of put that on the record. But thank you, and thank you for sharing.
Any other questions from members of the committee? All right. I don't see any, so thank you again for your presentations. We will move to testimony in support of SB 322. Anybody wishing to give supporting testimony is invited to the tables in Carson City and Las Vegas, and we will start up here in Carson City whenever you're ready.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. My name is John Jones, and I'm here on behalf of the Nevada District Attorneys Association testifying in support of SB 322. In Clark County alone, we've had 1,292 traffic-related fatalities since 2017. 1,292. And those numbers have been growing since 2019. As you heard today, one of those 1,292 people we lost was Rex Patchett. And I want you to take a moment and think of Jason Patchett and his family. Behind every traffic-related death resulting from a collision, there are countless numbers of parents, siblings, relatives, co-workers, friends, all of whom suffer immensely when a life is needlessly taken. The purpose of this bill is to increase penalties on drivers who kill innocent people while excessively speeding on our roadways and in our pedestrian safety zones. Our hope is that this increased punishment will deter drivers from engaging in the same behavior that you heard about today. No family should have to endure what the Patchett family has endured. On behalf of the Nevada District Attorneys Association and the families of victims of traffic violence, I urge you to support Rex's law. Thank you.
Good afternoon, Chair, members of the committee. Jason Walker, Washington County Sheriff's Office, testifying in support Senate Bill 322. I've worked on our major accident investigation team and have witnessed and investigated this horrific crashes firsthand. I feel anything we can do to keep our roadways safer is the right thing. It seems as if the general motoring public is driving faster every day, and then you have the reckless driver that's faster than all of them. This is a good bill. Thank you to all the sponsors that brought this bill forward.
Hello, committee. Elise Monroy Marsala here today on behalf of the Nevada Public Health Association. The Public Health Association's members include trauma surgeons and traffic safety researchers, like you heard from today. So the public, and I had a whole bunch of data, which I'm going to spare you because you've had a lot of really great data today. But one thing I'll just point on here is a lot of the data that you heard today is data about situations that are preventable. You don't have to speed. speeding, these are preventable things, and all of these deaths are preventable. So the Public Health Association supports policies that seek to end or limit preventable deaths. So the Public Health Association supports this bill and hopes you will too. Thank you.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. My name is Jeff Rogan. On behalf of Clark County, we urge you to support Rex's law. This is a needed policy change for all the reasons that have been stated here today and many more. There are just too many deaths on our roadways, and this is one way that we hope that we can deter those types of deaths and ensure that no one has to endure what Jason Patchett's family has had to endure. Thank you.
Chair Scheibel and the Senate Committee on Judiciary. My name is Chris Reese. It's R-I-E-S, and I represent the Las Vegas Metropolitan Police Department. We strongly support SB 322, Rex's Law. I want to echo the comments of the Nevada District Attorneys Association, so I'll be brief. I do want to thank Senator Stone, Assemblyman Urick, and especially the Patchett family for this important legislation. Thank you.
Thank you. Good afternoon, Madam Chair, Committee. My name is Zach Bucher with the City of Las Vegas. Pleasure to be here with you today. A very poignant, heart-touching testimony we heard today. Even though the City of Las Vegas only prosecutes misdemeanor crimes, felonies that we're talking about today are prosecuted by the district attorney. This is still a problem in our community, reckless driving. So we're here today urging your support, and I thank you for your time.
All right, I don't see anybody else in Carson City coming to the table, so we'll go down to Las Vegas if there's anybody wishing to give support testimony on SB 322. But I don't see anyone, so instead we'll go to the phones for support testimony on SB 322.
If you would like to testify in support of SB 322, please press star 9 to take your place in the queue.
Good afternoon, Chair Scheibel and members of the committee. Greg Herrera for the record, H-E-R-R-E-R-A, representing Nevada Sheriffs and Chiefs Association. We are in strong support of Senate Bill 322 and like to thank Senator Stone and Assemblyman Urick for bringing this bill forward and assisting in strengthening Nevada law enforcement's ability to keep our roadways safer. I'd also like to thank Mr. Padgett and his family for sharing Rex's story. These tragic stories have become much too common across Nevada. Please join us in supporting SB 322, Rex's Law. Thank you very much.
No.
We can hear you. Go ahead.
Hi, this is Vanessa Aguilar, also with my mom, Norma Aguilar, and representing the family of Savannah Aguilar, who was a victim of reckless driving in Nevada in 2017. And we're just here to support the bill and the Patchett family as well.
There are no further callers to testify in support.
All right, we'll move to opposition testimony on SB 322. I don't see anybody coming to the table in Clark County, Carson City, or Clark County. So we'll go to the phones for our opposition testimony on SB 322.
If you would like to testify in opposition, 322, please press star 9 to take your place in the queue or raise your hand. We have no callers to testify in opposition.
All right, then we'll move to neutral testimony on SB 322. Anybody wishing to give testimony in person is invited up to the tables in the front, but I don't see anybody in Las Vegas or Carson City, so we'll go to the phones for neutral testimony.
If you would like to testify in the neutral position for SB 322, please press star 9 to take your place in the queue or raise your hand. We have no callers testifying in the neutral position.
All right, then that brings us to the conclusion of testimony. If the sponsors would like to make any closing remarks, please go ahead.
Thank you again, Madam Chair. Senator Jeff Stone, for the record. First of all, I just want to make a couple of thank yous. I want to thanks to the presenters that came forward and the supporters. I also want to thank Senator Wynn for her collaboration on this bill and great suggestions. I also want to thank Madam Chair, you, for allowing us to hear this bill today. I can't tell you how much I appreciate that. I know the Patchett family certainly appreciates it. I want to thank Assemblyman Urick for all of his public safety knowledge in helping me craft this bill. And obviously to the Patchett family. Jason made it very clear that he's here today. It's not going to bring Rex back. But he does not want another family to have to witness the carnage and the loss that his family's had to endure. And I appreciate his whole family coming up here and their courage and their altruism. And so what we've witnessed is that we witness Rex's life cut short, but his name can and will hopefully live for a long time in this bill that hopefully will become Rex's law with your support. Thank you very much for your consideration.
Thank you, Chair. Assemblyman Toby York, for the record. I just want to also thank the Patchett family for the courage that they have demonstrated in the face of a horrible tragedy to try to make an impact and reverse the trend that we've been seeing recently. I want to thank the committee for taking the time and also hearing this bill, and for all. It was a collaborative effort of stakeholders that came together to try to put together a piece of legislation that will help address this growing trend. So thank you very much, and we encourage your support of SB 322.
Thank you very much. I will now close the hearing on SB 322, and I will hand the gavel over to Vice Chair Harris.
Thank you, Chair Scheibel. We will go ahead and open up the hearing on Senate Bill 417, which revises provisions governing common interest communities, and welcome our chair to the table.
Thank you very much. My name is Melanie Scheibel. I am the state senator for District 9, and I am happy to be presenting this committee bill, Senate Bill 417. You are all well aware of the historical tensions that have existed between HOAs and their members. It is a common topic of conversation here at the Judiciary Committee, but I'm heartened to see that the room is not full, so hopefully we have not turned out all of the, the most contentious issues in this. We haven't turned out everybody because this isn't the most contentious issue. That's what I'm trying to say. Some of the actions that we've taken to protect HOA members have gone a little too far and exposed executive board members and their employees to harassment. They've also put expensive demands on boards to fulfill unit owners' requests for records that sometimes have no bearing on the issue at hand. Senate Bill 417 tries to rectify some of these errors, to seek balance between boards, their employees, unit owners, to ensure that people who work for the HOA, who answer the phones in the office every day, who respond to unit owner emails are not subject to harassment, bullying, or even criminal activity. I'm joined today by my co-presenter who I think can, and some other folks from the industry who I think can give you some more information about the kinds of violence that HOA leadership and HOA staff have actually been facing in recent years, including death threats, including people following them, people vandalizing their homes and cars, and nobody deserves to experience that kind of intimidation or harassment. And so where the law has previously required that HOAs continue to interact with unit owners who may be engaged in this behavior, the purpose of SB 417 is to provide some safeguards that are not criminal in nature, but that allow the HOA board, the staff to carve out exceptions, and where unit owners are being more than just annoying, but where they are harassing or bullying those HOA staff members or board members, they can limit their interactions with that particular unit owner. So I'll walk through the sections of the bill and then pass it over to my co-presenter to follow up with some additional comments, and then we'll be open for questions. So Section 1 removes from the list of records that an executive board must make available for public review certain employee information like contracts, hours worked, salary, and benefit information. It also removes the $10 per hour cap that a unit owner or ombudsperson must pay to review an association's records, and instead requires that the fee reflect the actual costs incurred by the association. Section 2 prohibits a unit owner, tenant, guest, or invitee of an owner from taking or encouraging another person to take retaliatory action against an executive board, a board member, or staff of the association for doing any one of the following three things. 1, providing a unit owner with a notice concerning applicable law forming the basis of an alleged violation. Number 2, failing in good faith to respond to a request or demand within a prescribed period. And 3, refusing to provide confidential information or otherwise engage in unlawful activity. The section also provides that an action may be taken by the board, its members, or its staff to recover compensatory damages and attorney's fees and costs from a person who takes such retaliatory action. Section 3 includes the definition of the term violation as it relates to law governing common interest communities behavior that causes harm or serious emotional distress or the reasonable apprehension of such to a person in the association or that creates a hostile environment for that person. Section 4 allows the Commission on Common Interest Communities and Condominium Hotels to impose sanctions disqualifying a person from serving on an association board for up to 10 years who files a vexatious, misleading, retaliatory, frivolous, false, or fraudulent affidavit with the Real Estate Division of the Division of Insurance within the Department of Business and Industry. Finally, Section 5 would require the division to determine whether a violation alleged in an affidavit would constitute an actual violation before referring it to the ombuds for further action. There's also a conceptual amendment that you should have available to you today. That includes bullying as prohibited conduct under NRS 116.31184 in a manner analogous to the manner defined in NRS 388.122. And with your permission, Vice Chair, I would like to hand it over to my co-presenter now.
Of course. Go ahead and start whenever you're ready. Don't forget to state your name for the record.
Good afternoon, Vice Chair, members of the committee. My name is Adam Clarkson. I am the chair of the Community Association Institute Legislative Action Committee, also known as CILAC. CILAC is the industry's voice in the legislature. We represent over 1,300 members, most of which are community association leaders, but are also service providers for community associations. I'm a community association attorney. I've been practicing community association law since 2006. We'd like to thank Senator Scheibel for bringing this important bill forward for you guys today. And to just go over, because the Senator did a good job, very thorough job of covering the sections and what the changes are, I'm just going to briefly explain why we want them and why they're important to community associations. So Section 1, we call it, at CILAC, we call it de-weaponizing document request. And the reason we call it that is because it has become a method of continued harassment for homeowners. It's like there's a website somewhere that tells people to use this method to harass their managers and their volunteer board members by just asking for things. And I call it, it's like the Old West evil cowboys shooting at the shopkeeper's feet, and they just ask for document after document after document. We have associations that have tracked these things. People have asked for 100 documents in a period of 3 months. We have people who have asked for hundreds and hundreds of documents requests in a period of a year. And the thing is, the way the statute's currently set up, all those costs get shifted onto the membership at large. So that means that there's one person asking for a bunch of information, and in most cases, that information is already available then through the association's website. Because as you guys recall from SB 378, which we presented last week, much of the association information is already online. So all folks have to do is log in to get it. But they're asking for this information routinely. And really vexatiously. Some of these folks are asking for the same thing over and over again. They'll wait a few weeks and they'll ask for it again because they know that management has to go get it. And if management doesn't go get it, then they file a complaint against management. And they basically use this as a method of harassment. And so what we really want to see is that this be shifted so that the burden is balanced. We absolutely believe that community association members should have a right to review their documents. But we think that should be balanced against the interests of the other community association members that are paying for them to be able to review those documents and also manage it themselves, because standard management contract includes keeping up the financial records, keeping up information and providing notices of membership and running meetings, but it doesn't necessarily include going off and providing thousands of dollars of services a month to one individual homeowner who wants to ask for just an inundated amount of documents on that manager. So we would like to shift it. So if someone wants to review it and they legitimately want to look at documents, they can look at those documents, but they're going to do it at their own expense as opposed to shifting it to the membership at large. That's what is important about Section 1. Also, changing the documents to take out the information that the employees, that they can get about employee information. The employees are the people that really know about the employees of the association. That's the board. The board knows what the employees do. They're reviewing them. They're essentially supervisors of those employees. They have access to that information about the individual employees. The members don't need that information. They don't need to know what a specific individual employee makes, what their bonuses are, what their benefits are exactly to the letter. The only times we've seen that utilized is for them to harass those individuals. They find out what they make, and then they start harassing them online in other manners. So really, it's not, it's only been used for abuse. We've never seen anybody actually use it for any credible reason. And the folks that do need that information have access to that information. Moving to Section 2. Currently, it's important to understand that current law already provides unit owners with a right to pursue their board members and their management members for retaliation. So they have a right to make a retaliation claim against those individuals. However, if the board members or the managers are retaliated against by unit owners, which is really the most common situation, they don't have a reciprocal right. So they're denied equal protection of the law. So what we're doing here is really giving equal protection of the law, and that's what we've asked for, and that's what we're looking for in that section right there. The conceptual amendment adds bullying to NRS 116 31184. 31184 already prohibits other inappropriate acts that are considered harassment of individuals, and that applies to everyone. So this isn't adding bullying as protection just to board members and managers. It's also adding a protection to other community volunteers, committee members, and any homeowner. So any resident and homeowner of a community, a tenant of the community, they all receive equal protection of this bullying provision being added in the statute. We think it's a good provision because people should feel safe and comfortable in the places they live. Section 4 broadens the real estate division's ability to address persons who submit vexatious complaints to the real estate division. There's a lot of complaints, and hopefully the real estate division will be able to speak to that today, but they receive a lot of complaints from people that are just routine filers. They're getting, and it's complaint after complaint after complaint from the same people who are really just using that part of the system to harass their association. What we're proposed to add to this is that a consequence. Basically, if you are filing vexatious, misleading, retaliatory, and frivolous complaints, that you can be responsible for that. So even if you're on a board and you're filing them against someone, or if you're not on a board and you're filing, if you're a unit owner and you're filing them, or if you're a manager and you file these inappropriate complaints, that you can be responsible. And it could be a suspension of your ability to serve on the board. or preclusion of you being on the board, because folks that are doing this, these types of people, aren't the type of people that should be volunteering in a leadership position in the community. These are bad actors. These aren't good people. And similarly, this reduces the requisite knowledge of the person. Right now, for the real estate division to prosecute someone who files a frivolous or vexatious complaint, they have to be able to prove that they knowingly filed it. They had to know that it was vexatious, frivolous. And these people always feign ignorance. They go, oh, I didn't know I was lying. So what we're doing, we've taken that knowingly taken it out, so that it's really just going to be that more likely than not, the matter was it was filed vexatious, misleading, retaliatory, or frivolous. So more likely than not, that was the situation, so they'll be able to prosecute. So this is in part designed to protect homeowners, managers, and other volunteers, and it's also designed to reduce the cost upon our real estate division. It's going to reduce overall governmental cost, because we're going to reduce the number of complaints they're going to have to deal with, because they're not going to have to deal with these frequent flyers who are just coming to them over and over again. The next section, Section 5, it has a similar effect as well, as far as reducing government cost in handling things with community associations. It allows the division to determine that an alleged violation, if assumed to be true, would constitute a violation of the charter. So if it determines that, even if the facts were true, it's not a violation of law, they don't have to investigate it. Because right now, there's a lot of pressure on them and expectations in the way the law is crafted. They feel like if there's a claim submitted, that they need to initiate an investigation. Now, that costs resources on their end, because they have to start the investigation process, they have to review it, they have to send out letters and engage in communications and reviews with the third-party community associations. It costs the community associations, because the community associations have to respond to these letters. They have to review them and respond to them. And the thing is, if it's something that was legal under NRS 116, or other Nevada law, and it's not a violation, then quite frankly, the division should be able to toss it. So they should be able to look at it and say, okay, we understand what you said, but even if what you said is true, it's still not a violation of the law, so we don't need to investigate it. And that's what that section's all about. Thank you for your time, and please let me know if there's any questions that I can answer for you.
That concludes our presentation, and we're open for questions now, Vice Chair Harris.
Committee members, any questions on Senate Bill 417? Okay, Senator Nguyen.
Oh, I just talked too much today. I'm sorry, you guys. I have a question. I've heard from a lot of people about people, I think in our world, in the criminal defense and prosecutorial world, we see a lot of times where you'll have vexatious litigants that have like a determination, and I liken this to this. So I think it was answered before by your presenter down south, but would this prevent people from being able to come in and repeatedly request documents that often take time and money? And this isn't meant to like prohibit people's ability to get it. It's to prohibit those like 10 people that are requesting hundreds of thousands of dollars in documents. So would this help prevent some of that?
I can answer that question. Adam Clarkson, for the record. So yes, basically the entire bill overall would prevent that. It would both deter it and prevent it. With respect to Section 1, it's going to deter it, because it's still going to allow, technically folks that want to keep asking for these documents will be able to still continue to get that, but instead of doing it at no cost to them and pushing that cost to the fellow members, they're going to have to pay for it. So if they want a landscaping contract from 10 years ago, they're going to have to pay the cost of having those records pulled from storage, and then the copying cost or whatever cost it takes to put that together. So it's going to deter that. And on the real estate division level, it's going to allow the division to simply essentially disregard their complaint, and they can prosecute them for filing a vexatious complaint if they keep filing it to the division. So yes, it absolutely accomplishes that on two different manners. Thank you.
Any additional questions? Senator Stone.
Thank you, Madam Vice Chair, and thank you, Madam Chair, for bringing this forward. My wife is a board member of an HOA, so a lot of what you're describing here really hits home. And unfortunately, sometimes you have people that just don't like the rules that you make for the HOA, and they will do everything they can to recall you and attack you, and so they deserve protections as well. So in your section 4, if someone is being vexatious, is that the right way you pronounce that? Misleading, retaliatory, frivolous, files false or fraudulent affidavits. It would be the HOA then files a claim, if you will, with the real estate division of the Department of Business and Industry, and it would be that department that would give the prohibition that somebody can't run for up to 10 years on the board. And is that correct?
Melanie Scheibel, for the record, yes, that is correct.
Okay. And so there will be like a quasi-hearing office. So my only concern is that sometimes when you put misleading, sometimes people are ignorant, unfortunately, and have wrong information and base their information on that ignorant information. And while the misleading sometimes can be an honest misleading if there's such a case for that. But also, with regard to personnel records of the employees, I agree 100% that information should not be disclosed, but that will not prevent an association as a part of a budget process for telling the members of the homeowners association what the cost is for that management service. They could cumulatively say, you know, it's going to cost you $5,000 a month or $10,000 a month without revealing the specifics of what the employees make or any other pertinent information.
Melanie Scheibel, for the record, and yes, that's correct. They can still provide that general information, but this is to avoid giving bullies the tools to find out exactly what someone makes or exactly what hours they work or exactly who opens up the office on Tuesday mornings at 8 a.m., things like that.
Yeah, I appreciate you bringing this forward. Happy to support it.
Okay. Not seeing any other questions, we'll go ahead and open up for testimony. Anyone here in Carson testify in support Senate Bill 417?
Vice Chair, members of the committee, Samantha Sato with Career Nevada on behalf of the Nevada Association of Community Managers in full support of Senate Bill 417. Thank you.
Okay, we'll go down to Las Vegas. If you'd like to testify in support, go ahead. Just don't forget to state your name for the record.
Hello, thank you committee members for your time on this. My name is Gregory Kerr. I'm the vice chair of the CAI LAC committee. I'm also an attorney. I've been practicing law here in Nevada since 2007, representing exclusively homeowners associations. Just to point out a couple, obviously I'm in support of the bill. A few things I wanted to note in particular was the issue regarding salary information and employment information for association employees. I will tell you, in my experience, the only persons or homeowners that typically request that information are those that wish to use it improperly or as a manner to attack or harass association employees. And it doesn't matter if the community manager makes $1 a year or $100,000 a year. It's always too much, and they always need to be fired, at least according to the owners that typically ask for this information. The information ends up on websites, on the website next door, on Facebook, emails, to harass and embarrass the managers. And I think this bill will bring some protection to those employees, at least on that front. So I wanted to emphasize that point. I think it's a good portion of the bill. The bill is good overall. I wanted to highlight that portion. Also, Section 3 of the bill gives the Nevada Real Estate Division the jurisdiction to enforce the anti-harassment statute, which is in NRS 116-31184. Right now, violations of that statute are deemed to be a misdemeanor. They're only enforceable through law enforcement. Law enforcement typically does not have the time or the resources to enforce this statute. I've never seen it enforced by law enforcement. This will give the statute some meaning and some actual application if the real estate division is also able to enforce those particular violations. And that benefits everybody that's benefited by that statute: homeowners, managers, board of directors. So we're in support of this bill. Thank you for your time.
Good afternoon, Vice Chair and committee. My name is Ann Calarco. I'm actually a member of the CAI group, presently serving on several committees, one being the LAC. But in addition to that, I'm also an owner and president of a community management company, as well as being a board member on my property for over 17 years. So I've seen some of this play out all the way around. I am totally in support of the revisions to SB 417 for a variety of reasons, but the main concern I have is that in the course of trying to accommodate homeowners' requests that are received in writing and asking for copies of documents, and in some cases, as a prior speaker mentioned, some of these documents have been in archives and storage and kept by prior management companies for over 7 to 10 years. In the course of presenting and pulling and assembling all of those documents that they request, I have 2 to 3 of my staff members, not just the manager, not just the administrative assistant, but I have several people in my company that have to work together to accomplish pulling all of this and requiring all of that being done in a timely manner within this 21 days. What we do see in many cases is that a homeowner who has a particular group of issues, or as one of your senators mentioned, has a particular axe to grind and is unhappy with rules, regulations, or actions that have been taken by the association. And what happens is it's the best defense is a good offense mechanism, which is to bombard the manager on a weekly or other daily basis, providing their email written documentation to request all of these, but to request them in such a way that it puts that manager and it puts the staff of my company, as well as my company, myself as a supervising CAM, in a position of trying to meet every piece of required documentation within that 21-day period from the date of every one of those emailed requests. It becomes cumbersome, it becomes extremely expensive from a labor standpoint, and once again, it's the association client that usually has to bear that burden of cost as additional items billed within my management agreement. So I fully support the amendments, and thank you for your time.
Okay, BPS, can we check the phone, see if there's anyone who'd like to testify in support for Senate Bill 417?
You would like to testify in support of Senate Bill 417, please press star 9 to take your place in the queue.
Madam Chair, may I speak? This is Lori Berger.
We can hear you. Yes, go ahead.
Yes, hi. My name is Lori Berger. I'm a supervising CAM, and I'm a member of the CAI LAC committee. I serve as a regional vice president for my company, and I work out of Reno. I'm speaking in support of SB 417. As a manager, I am pleased always when a homeowner calls and requests information. We're here to help and glad that they are engaged. SB 417 helps to strike a balance, and we need the protections of this bill. Sometimes owners make numerous requests over and over. We have, while some of them may be very excessive, time is of the essence. As we've heard before, we only have 21 days. So we really don't have a lot of time to go ask questions and figure out what we need to do. We need to get the information out to the homeowner and protect our licenses and the association. In my last document request from a homeowner, there were 25 different categories, and it took us 65 hours to produce the documents. If I just speak to the financial request of the homeowner, they requested 9 years of general ledgers, 9 years of monthly financial reports, 9 years of all bank statements, 9 years of copies of all checks, all invoices, and contracts. Well, in some cases, we can pull stuff electronically. It's true, a lot of that stuff is in storage, but it's just not producing the records. The general ledgers need to be redacted. We need to remove homeowners' names. We need to remove payments made to sensitive people that a homeowner shouldn't know. We need to remove bank account numbers. And of 432 bank statements, someone needs to sit down and redact all the bank account numbers and other sensitive information. The delinquency reports need to be redacted from the financial reports, and thousands of invoices need to be reviewed. This is a problem, and this bill will really help the management companies. In Section 2, I just want to speak to one instance. I had a community manager circulating through a property, doing a property inspection, and a homeowner came out and spoke with the homeowner. The manager did. The person got in their car, it was a Tesla, followed the manager through the property, onto the freeway. They called the police department for assistance. They pulled off the freeway at another ramp, got off the freeway where they were met by several policemen. The homeowner didn't get anything wrong. I mean, the police just told him to behave and go away, but it petrified our manager, and we desperately need this protection. Thank you.
Hi, this is Valerie Santana. I'm a manager in Reno, a member of CAI. I'm also a partner in a small management company. I want to voice my support for this bill, just as the others have said. We've all experienced this type of behavior from a homeowner with an axe to grind for whatever reason, and it is burdensome, and it's a risk to our licenses. I, as a small management company owner, have the ability to be able to say to the partners, we don't need this kind of business, and give our notice to an association once the contract ends, but many managers don't have that ability in a larger management company and have to continue to tolerate the abuse. And it's just not right that there's not an equitable solution to protect managers from homeowners that are behaving in this manner.
Yeah, good afternoon. My name is Rhonda Tyson. I'm the president of a 100-unit condominium association. I speak in support of SB 417, and I want to give you 4 separate examples of what I've endured during my short tenure on my board. There's the homeowner who sent an email to all the board members advising them that he had a concealed carry permit, and everyone should assume he was armed when they saw him on property. There's the owner who was disappointed in a board ruling and made 3 consecutive complaints to the real estate division alleging the identical set of facts, each time dismissed as being unfounded. There's the owner who decided to do his own plumbing without a permit or a licensed plumber and flooded his downstairs neighbor. When the board sanctioned him for that behavior, he filed a recall petition in order to try to remove the board members. Of course, board members cannot discuss his violation because it's confidential, so he can lie about his reasons for doing so. Last but not least, there's the owner who graffitied the stairwell outside a board member's apartment that he perceives to be gay. It was a smiley face, and it was tagged, "God hates fags." People like to talk about bad boards, but you will never have good boards unless good people are willing to serve, and good people will not be willing to serve as long as they're subjected to that kind of harassment. So I ask you to support SB 417. Thank you.
We have no further callers in support at this time.
Okay, thank you. We'll go back down to Las Vegas. It looks like there's someone else who'd like to testify in support. Go ahead, sir.
I apologize. Thank you, Madam Vice Chair and the committee. My name, for the record, is Robert Allen Forney. I'm with Complex Solutions. We do reserve studies in Nevada. We're the largest company that does reserve studies in Nevada. I am on CAI's Legislative Action Committee, but I have not vetted with them what I'm going to say today, and I would like to make clear that I'm representing myself as a vendor that serves homeowners associations. I would like to read a couple stats here. These are from Zogby Analytics. They were commissioned by CAI Research Foundation. Approximately 518,000 Nevadans live in more than 3,490 community associations. These residents pay $920 million a year between their communities. Those are costs local governments in Nevada don't have to bear. 84% say they always or usually vote in state and local elections. 89% say their association rules protect and enhance their property values. So these are high quality people. 74% say their community managers provide value and support to residents. And I would like to give an anecdote that happened to me. A gentleman who, in my opinion, got on his board for the sole purpose of causing more problems, having more power, clearly read every statute that had to do with reserve studies and asked me an insane number of questions, asked for copies of a lot of things. At first, having no experience with this before, I tried to accommodate the person, then I tried to placate the person, and then I had nothing to do with the person because I realized I was only giving ammunition to this individual to cause more problems with his management company. And finally, I would like to say that there is no such thing as an HOA. There is no such thing as an HOA. An HOA is only a fancy name for a collection of people that live in a neighborhood and they come together to try to maintain the value of that neighborhood for themselves, and they bring value to the state of Nevada. And we should be concerned with those individual homeowners and the community managers in our state who, and I can tell you with some authority, are the best, most educated in the country, serve those homeowners. So I would like to voice my opinion as being in support of SB 417. Thank you.
All right, we'll come here to Carson City. Is there anyone here who'd like to testify in opposition to Senate Bill 417? Okay, not seeing anyone. We'll go down to Las Vegas for opposition testimony.
Good afternoon. My name is Mike Kozar, and I strongly oppose Senate Bill 417. I serve as one of only 2 elected directors on my Master Association board of nearly 9,000 units in my community. It has been controlled by my declarant for 23 years. Senators, we need to be seeking to advance board transparency, especially when boards are declarant controlled, and encourage greater participation of owners. I think there's no question that needs to occur. I have been a victim of a defamation action, the first legal action of my life. It was 5 years, a Nevada Supreme Court ruling, and nearly 7 figures in attorney fees, even when invoking Nevada's anti-SLAPP laws. While the developer lost its battle with me, the court, finding his actions a, quote, quintessential SLAPP, the developer and his appointed board won the war. My neighbors dare not be next. But they did subsequently elect me to represent them. I'm a retired Air Force colonel, fighter pilot with combat experience in the Gulf War. This experience, defending the attacks of this developer on my family's financial future, was in total the most stressful experience of my life. I agree, prohibitions on defamation and harassment have no place in an HOA. Okay? However, as this law is written, particularly Section 2 and 3, it will allow the association to determine what they consider defamatory and harassment, and ultimately provide the association the ability to censor free speech based on positions from that of the board or the declarant if it's appropriate. This section of NRS 116 was intended back in 2013 when it was first added to provide the division and commission powers to protect homeowners, HOA, corporate boards, and management. Existing civil laws dealt with owners' misconduct and still do. What is now proposed creates a new crime and flips the protection on its head. It is an assault on the First Amendment, an end run of Nevada's anti-SLAPP laws, and generally works to chill owner opposition to the governance of their communities, not to mention a rainmaker for the attorneys and management companies. Hopefully it's not lost on you that the folks that spoke in support of this bill were almost entirely CIA representatives, a lobbyist group. Where are the homeowners being represented? Senators, we've got to turn to you for that representation. We're not down there in your offices and have the kind of access these groups do. I can speak to each of them, of the sections. Just briefly, I'll speak to section 4. 10 years for abusing or in ultimately misleading affidavit seems to me to be rather difficult, particularly considered a convicted criminal, once released from probation, is only restricted to 4 years. Section 5 seems nonsensical to me, adds more complexity and allows it beyond. If you are going to assume an alleged violation is true, isn't that a violation? I guess I'm not sure how that's going to help, other than it will allow the division to simply disregard, without going to the ombudsman, who's supposed to be representing us to track what's really going on in the Nevada Real Estate Division for accountability. Finally, I'll conclude with this: allowing actual costs as prescribed in this bill isn't being prescribed in any other organization. Okay? You can use that to weaponize the ability to deny homeowners their right to get information. These homeowners already pay a management company for that service. Yes, there's going to be abuses in anything, and let's target the abuses. Finally, I would suggest to you that there's a lot of counterpoint to the comments that were provided here. Simply asking for information when you don't get an answer, what is your recourse but to ask again? Okay? I'll be available to answer questions and would certainly love to answer questions. I'll conclude by saying the CIC task force was enacted in 2019 by legislation through this committee to bring these kind of laws, after being vetted by a complete group, to you for consideration. In this case, that committee has not been active for 2.5 years. I think this would be a great opportunity to put it back to work. Thank you very much and appreciate your time and attention.
All right, thank you. We will go ahead and go to the phones. Anyone on the phone, BPS, who'd like to testify in opposition to Senate Bill 417?
If you would like to testify in opposition for Senate Bill 417, please press star 9 to take your place in the queue.
Hello?
Go ahead, sir. We can hear you.
My name is Samuel Covelli. I am a retired Nevada Correctional Sergeant. I'm a Nevada Vietnam veteran. I'm a homeowner. I'm in Las Vegas, Nevada. I've lived in this HOA for 22 years. Like most of the people that live here, I didn't pay attention to what was going on. Everything was hunky-dory. Last year, I started requesting documents because I'm now a retiree. I requested a simple audit. of the association, which is required by law. And I'm speaking in opposition to this law, this bill you're trying to pass. Most of it's arbitrary and capricious. It gives already over-advantaged lawyers, community managers, and unscrupulous boards the ability to silence homeowners. I've been battling this for a year, trying to get simple information. I get cease and desist letters. I am put through the process. Number one, someone mentioned you could go on a website and get the information we request. Not in our situation. It's just not there. So you send a kind email requesting the information, you're ignored. 21 days later, you send a letter, return receipt request that you have to pay for. Again, you're ignored. Then you can file a 530 complaint, which has to be notarized. If you've never filled one out, the average homeowner couldn't do it. It's prohibitive. This process is so convoluted to start with, and now you want to completely convolute this thing for the benefit of CAI. I'll cite one thing here in Section 2, Paragraph B. They can take action against you. You can't take action against them if they fail in good faith to respond to a request or demand within the prescribed period pursuant to the governing documents of the association or 116. This is arbitrary and capricious. What do you mean you denied me in good faith? 116-31175 says you must provide me with financials. I haven't made unusual requests, but I'm stonewalled constantly. I am forced to use the ombudsman's procedure, the 530 process, no matter what I ask for now. This whole bill, the whole crux to this thing is to boost these community managers, unscrupulous boards, and the attorneys' ability to stonewall us. The gentleman that spoke in opposition before me, I applaud you. You hit the nail on the head, although he's dealing with declarants. This process is not in favor of the homeowner. It is horribly slanted against the homeowner now. This will make it even worse. And I see possibility here that there are attorneys that are listening to this. There's some First Amendment stuff in here that will deserve a challenge. But back to my original statement, this whole process, the ombudsman's hands are tied, and their process is arbitrary and capricious. If you point out an actual violation of NRS and give them a document, a check that is a violation of NRS, the attorney comes in and says, that was just once. Well, I give you 1,200 pages with a bunch of violations in writing. They're documents. They're financial documents that were sent to me that I finally got after going through this horrible process. It's ridiculous. I'm sure there are good HOA boards. I'm sure there are good management companies. I'm sure there are good attorneys in the community representing people. But this whole process is horribly slanted against a homeowner. I'll take some of the blame for not paying attention to what went on in my HOA for 20 years.
And sir,
but now I am requesting document. Yes.
Sir, we haven't put a time limit on the testimony, but we do have to make sure we get to neutral as well as public comment for the day. If you could wrap up and please submit any additional comments that you have in writing to the committee, that'd be greatly appreciated.
Well, I'm going to say this. I don't think it'll do any good, number one. I think this is already a cut and dried thing. But I do want to be on record as saying that this is a horrible, horrible disservice to the homeowners in Nevada. And I'm done speaking.
Yes. Yes.
We can hear you, sir. Go ahead.
Thank you for the opportunity to speak in opposition to SB 417. My name is Howard McCarley, and I'm a resident of Las Vegas. One of Governor Lombardo's first acts was an executive order asking state agencies to reduce the number of regulations in Nevada. Rather than reducing bureaucracy and regulation, the changes proposed in SB 417 increase the scope and breadth of regulations regarding HOAs. When I go on the internet and type in HOA, I can find thousands of stories from homeowners and HOAs telling horror stories of mistreatment by HOA boards and management companies. What I have never seen is an HOA board or management company crying about being harassed or threatened by a resident. There's a reason for this. There's an imbalance of power between homeowners and homeowners associations and management companies. Extensive financial resources are available to associations and managers. Residents are on their own. The cost of providing information requested by residents is or should be built into assessments paid by residents. Within Nevada revised statutes, there are numerous provisions that can be used to protect employees and organizations from harassment or defamation, but that would require complaints in a venue other than one substantially controlled by real estate interests. They want the ability to define the terms to suit their purpose. The changes are unnecessary and place an unreasonable burden on residents unsatisfied with the performance of an HOA or management company. They are intended to silence critics of the performance of management companies and HOAs. More positive moves would be utilize the Common Interest Community Task Force that was set up to look at HOA regulations and suggest changes. Did that committee review the suggested revisions? Move the self-funded Ombudsman's office out from under the real estate division and place it in the AG's office. Require a review of all proposed CC&Rs for form and content before recording. Ensure that the CCRs protect the residents, not the developer. Given circumstances in the country right now, do we really want to entertain another impediment to people being able to question how they're being governed, question how contracts are awarded? Ask yourself if the proposed changes enhance the rights of homeowners. Are they in furtherance of the already unbalanced powers of HOAs and management companies? Thank you for your opportunity to express my opposition to the proposed changes.
There are no further callers to testify in opposition.
Okay, thank you. We will come back here to Carson for neutral testimony. Anyone like to testify in the neutral position on Senate Bill 417? Not seeing anyone, we'll go down to Las Vegas for neutral testimony.
Good afternoon, Madam Vice Chair, members of the committee. Sharath Chandra, S-H-A-R-A-T-H, C-H-A-N-D-R-A, Administrator for the Real Estate Division. Just testifying neutral and available for any questions that I may be able to answer. Thank you.
I don't think we have any questions for you today. Thank you. BPS, can we go to the phone lines to see if there's any neutral testimony?
If you would like to testify in the neutral for SB 417, please press star 9 to take your place in the queue. We have no callers to testify in neutral at this time.
All right. Chair Scheibel, if you'd like to make any closing comments. Okay, we'll go ahead and close the hearing then on Senate Bill 417, and I will turn the gavel back over to its rightful owner.
All right, thank you. That takes us to public comment. Anybody wishing to give public comment in person is invited to the tables in Carson City and Las Vegas. Public comment will be limited to 2 minutes per person and can cover any topics that we discuss here that are covered by the judiciary's jurisdiction, but can't be about any particular bill that we've heard today. So I see somebody down in Las Vegas. Please go ahead and begin.
Thank you, Madam Chair. For the record, my name is Mike Kozar. I have provided each of the senators an email with my discussion, my topic here in that email and supporting documents. I've also provided you with a published article in 2022 that I believe sets up a very dangerous situation here in Nevada. At issue was a fight I had with the Nevada Real Estate Division's interpretation of a statute, that being NRS 1162117. The statute provides a repose after 1 year if you do not legally challenge that amendment. NRED has interpreted the statute of repose to be applicable to all amendments. As you probably know, or it should be important that you know, most CC&R amendments, currently, certainly in the first years of an association, are unilateral efforts of the declarant. Okay? Typically inappropriate under limits set in NRS, a declarant can add, modify, and subtract proposed from amendments. A declarant can even correct minor scrivenercy errors. The problem arises they are not adopted amendments. They require no owner education and, most importantly, no vote. Yet today they are entitled to a repose despite the clear intentions in plain language of the statute that the repose apply to only adopted amendments. Senators, our courts have inexplicably upheld the NRED's ability to interpret the statutes. I think both are wrong. I would ask you to take a hard look at this, and you, frankly, only you can do something about fixing the current dangerous precedent that now establishes. Thank you very much for your time.
All right, thank you. I don't see anybody else wishing to give public comment in person, so we'll go to the phones for public comment, please.
If you would like to provide public comment, please press *9 to take your place in the queue.
Anne Murray Grant, ANNEMARIEGRANT. My brother Thomas Purdy was 38 years old when he was murdered by Reno police in Washoe County Sheriff's Office during a mental health crisis, hogtied for over 40 minutes and asphyxiated to death. Since last legislative session in 2021, 47 human beings, somebody's loved one, have died during interactions with police in Nevada. Today I'd like to remember the 17 veterans who could survive war but could not survive the police in Nevada. Darren Dyer, 92422, David Freeman, 81103, Marines, David Kuhn, 4914, Marines, Efrey Trujillo Serrano, 41116, Army, Eric Scott, 71010, Marines, Francis Spivey, 22515, Air Force, James Wayne P, 5720, Navy, John Paul Hamilton, 7109, Army, Kenneth Stafford, 71113, Army, Leon Buck, 81706, Navy, Lloyd Nupik, 102718, Marines, Robert McKinney, 5101, Army, Ronald Neal Joseph Jr., 6607, Stanley Gibson, 121211, Army, Tommy Pirtle, 113014, Marines, Tommy Lee Guest Jr., 81201, Army, Owen Earl Barton, 11620, and that's it. Thank you. I would like to say that there are constitutional violations happening at the Washoe County Jail currently, and you all should look into it. Thank you.
There are no further calls for public comment.
All right, thank you so much. That brings us to the conclusion of our meeting today. It is my intent to start again tomorrow at noon to give us a little bit more time to hear bills and make it to afternoon committees. But we will confirm that tomorrow on the official agenda and look forward to seeing you then. Until tomorrow, we are adjourned.